The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about the doctrine of res judicata in Illinois divorce cases. So the doctrine of res judicata is a legal doctrine that states that parties can't relitigate the same issues that were decided in a previous case by filing a second case. They can't relitigate issues that could have been decided in a previous case either. So when someone files basically the same lawsuit over again after an order has been entered, a final judgment has been entered on the same or a similar claim, the party that is the lawsuit is filed against can file a motion to dismiss and have the case thrown out based on the doctrine of res judicata by saying we've already decided this in a previous final order. The elements that are necessary in order for the defense of res judicata to apply are that there's an identity of cause of action, meaning that the claim was already decided in a previous lawsuit or could have been decided in a previous lawsuit but was not raised. Secondly, a final judgment on the merits of the case had to have been entered in the previous lawsuit by a court that had jurisdiction to enter that final judgment order. And finally, the parties had to have been the same between the two lawsuits. So if it's a different defendant in the case of civil litigation, it might be the same claim as the first lawsuit, but a different defendant. Res judicata would not serve to bar the second lawsuit. So let's talk about how this doctrine of res judicata applies in divorce cases. There are several different topics that can be the subject to litigation in a divorce. That can include child support, child custody, spousal maintenance, and asset division or liability division, so division of debts and property. For most of these, res judicata doesn't apply. So for child custody or parenting time, for child support, or for spousal maintenance, a substantial change in circumstances can cause the parties to have to relitigate these basically over and over again as long as the parties are still alive. They can usually relitigate child custody, child support, spousal maintenance. They just have to show that there's been a substantial change in circumstances. And each one of these issues has a different standard by which you're allowed to modify them. And if you can meet that standard, you can modify the previous order. So you can't, if someone tries to change a child support order, use res judicata as a defense to that. You can't say it's already been decided. You can say that they haven't shown a substantial change in circumstances and haven't met the standard to change the order, but res judicata wouldn't come into play. So for custody and parenting time, child support, and spousal maintenance, res judicata is not a valid defense. That being said, if someone files a motion and it is denied and they refile the same motion, the judge is not going to hear that second motion. It's very easy to say, you've already decided this motion, judge. We don't need to have a hearing on it. That wouldn't be exactly res judicata because it's not a second lawsuit. Res judicata does apply to property division, though. So the division of assets and liabilities can't be revisited once a final order has been entered unless the person trying to revisit it can produce evidence of fraud, mistake, or duress that impacted the initial order. However, you can file an appeal if you're within the time limit to file an appeal to the appellate court. And in general, if you disagree with a court's ruling, there's other options that you have, post-trial motions that you can file, like motions to reconsider or motions for relief from judgment. And we have an article and video about post-trial motions you can check out at learn-about-law.com. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you watch your videos or listen to your podcasts. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.